Wendy, I think we can now start. It's already for 2:13, yeah?
Yes, please.
Thank you very much. Well, good afternoon, members. I hope your day has been a successful. And today we are being joined. Welcome to our new series of Know Your Tribunal. We had finished the last series last year in November, and we decided to embrace it again. So, as the new advocates have been admitted, and also the other membership who had missed to understand and grasp a better concept of our tribunal, so we decided to kickstart again. So today we are going to be having a one-on-one session with the Tribunal of the Advocate Disciplinary Tribunal and the Advocates Complaints Commission, where with us we will be having three key speakers whom need no introduction from you members. And I will start with the first speaker is Mr. William Maema, who is a senior partner at IKM DL Piper Africa, where he is currently the chair of the Advocates Disciplinary Tribunal. Senior Maema is an advocate of the High Court with over 30 years of experience, and he has quite a robust career, as most of us know. We've interacted with him. He holds a master's degree from the University of Cambridge. He went for his undergraduate at the University of Nairobi and did his his postgraduate diploma at the Kenya School of Law. Our senior William specializes in corporate commercial law, intellectual property law, employment, NGOs, and anything to do with regulatory compliance on corporate matters and governance. Our senior is also a member of very, very various international organizations that deals with IP, including the International Trademark Association, where he is actually served as a committee member. Due to his passion for IP, our senior has also taught IP, intellectual property law, and international trade, among other courses, at the University of Nairobi. He is a columnist at the Business Daily, where he writes on legal topics, especially on matters public interest. Welcome very much, Mr. William, our senior Maema. Our second speaker is Miss Mwadhi Gitonga. She is the current Deputy CEO of our noble profession at the LSK National Council Secretariat, and she's also the Director of Compliance and Ethics Directorate at the Law Society of Kenya. I'm sure most of us, when we are trying to apply for a letter of no objection, we will always see Ms. Mwadhi Gitonga doing the response to us. She is a high-performing legal practitioner of Kenya and an advocate of the High Court with a successful legal career spanning up to 11 years. She holds a bachelor's degree from Moi University, so she comes from my school. I'm also a Moi alumni. She has also done an LLM from the University of Kent and is currently undertaking her PhD studies in environmental law at the University of Nairobi. She has expertise in corporate law, environmental law. As you can see from her PhD, she's actually has an angle on environmental law, program management, also regulatory compliance. As you all know, she's the Director of Compliance and Ethics Directorate at LSK. Currently, she's deputizing our CEO, and she oversees the administrative functions of Advocates Disciplinary Tribunal. So she does work hand in hand with our senior William Maema. And in this role, it includes keeping track of all the disciplinary cases while enforcing orders of the tribunal. So, counsel, we need to be careful because this is the lady who will come after us if, by bad luck, will be taken to the disciplinary tribunal. She's also mandated with the regulatory compliance of advocates. She plays an instrumental role in maintaining the standards of professional practice and ethics, and also ensuring the functions of the advocates disciplinary tribunal are discharged expeditiously and effectively. Thank you very much, Ms. Mwathi, for agreeing to come and speak to our members. And our last presenter is Senior George Nyakundi, who's an advocate of the High Court of Kenya of over 27 years standing. is a seasoned civil servant, having worked for the government of Kenya for 25 years. Wow. Currently, he's serving as the Commission Secretary at the Advocates Complaint Commission, a position that he has held for the past 6 years. Thank you, Senior, and continue working for us Kenyans. Previously, Senior Nyakundi has served in different capacities as a state counsel within the Office of the AG and Department of Justice, namely the Advocates Complaint Commission, Administrator General on Public Trustees, and head of the Office of the AG and Department of Justice in Kisumu region. Thank you very much, Senior. Unfortunately, today we are dealing with Nairobi advocates, so we still embrace you as much as you work for Kisumu people. So members, with no further ado, I will welcome the floor. I will ask our first speaker, that is our, because of seniority, Senior William Maima, to open the floor. Welcome, Senior.
Thank you, Teresia, for inviting me. It's a great honor and privilege to come and share with you a little bit of my experience with the Advocates Disciplinary Tribunal. So I don't know where you want us to start. There's a lot to talk about. I was hoping that the intention of this discussion is to help our members to understand what the Advocates Disciplinary Tribunal is, the work we do, and how we do it, and more importantly, how to avoid getting close to us unless you're representing someone. So that is what I hope we'll be able to unravel by the end of this discussion. Thank you, Teresia. You're on mute. I think you're muted, unless...
Oh, sorry, I will. Thank you very much, Senior, for that. And also due to seniority, I will also welcome Senior George Nyakundi to brief the membership before we commence with the session.
Thank you, Teresia. I also thank you for welcoming me to this session to discuss the Advocates Complaints Commission. The commission is not really a tribunal, but it handles some matters relating to advocates. So hopefully you'll be able to learn something about the commission, what it does, and how members can interact with it, members of the law center in Nairobi. Thank you.
Thank you very much, Senior. Last but not least, I will welcome Ms. Mwati, who is the nexus between advocates and the Advocates Tribunal, because she serves at the LSK, who heads that secretariat team. Ms. Mwati?
Thank you so much, Teresia. It's my pleasure to be here. I'll basically just limit my discussion today to the role of LSK and how we act as a nexus between the tribunal and the Advocates Complaints Commission. So that's what I'll try to clarify for the membership. Thank you so much.
Thank you very much. Members, with no further ado, we are going to start with the first question. I will want to, our speakers, starting with our Senior William Maima, to elaborate to members what is the Advocates Disciplinary Tribunal and what it encompasses.
Okay.
And Senior, before you start, in the interim, you can also be sharing the slides as we progress. Thank you.
Okay, Teresia, you can hear me?
Yes, Senior, loud and clear.
Perfect. Okay, so members, let me start by just explaining what the Advocates Disciplinary Tribunal is. And the first thing, of course, to enable us to understand what this tribunal is to look at the legal framework under which it is set up. So if I can take you back to the Constitution, because that is the mother of all laws, you'll find that we have a basis or a foundation in the Constitution of Kenya 2010. If you look at Article 46, you'll see that it provides for consumer rights and states that consumers, including consumers of legal services, have the right to goods and services of reasonable quality, the information necessary for them to gain full benefit from the goods and services that they receive, and the protection of their health, safety, and economic interests. And I emphasize economic interests. They also have the right to compensation for loss in case of injury or defective services rendered. And when you look at Article 50, you'll also see that it provides for establishment of tribunals. And then you go to Article 165, which provides for judicial review. And our decisions are subject to judicial review. So that is the constitutional basis of the tribunal. Now, when you come to statute, you'll find the Advocates Act, Section 55, which describes advocates as officers of the court and states that we are subject to the jurisdiction of the court and the Advocates Disciplinary Tribunal. Looking at Section 56, you find the power that has been granted to the Chief Justice and judges to enforce professional discipline in respect of advocates that are appearing before them. And then Section 57 establishes the tribunal itself. Now, Section 60 is very important because it says that any person may lodge a complaint against an advocate. And I'll talk a little bit about this later because there is a bit of confusion about it. Still talking about the legal framework, the Law Society of Kenya Act has some provisions, relevant provisions relating to us. I don't want to go into that because of time. You look at the Public Officers Ethics Act, also has relevant provisions. And then there is subsidiary legislation, particularly the Advocates Disciplinary Committee Rules of 1990, which sets out the rules that we apply in handling cases that are brought before us. There is the Advocates Practice Rules of 1966, which also prescribes various types of conduct which would be a breach of professional ethics and professional standards. And then we have the Advocates Marketing and Advertising Rules of 2014, which regulate how lawyers can market their services. And more importantly, we have what is called the Code of Ethics and the Code of Ethics and Conduct for Advocates. In short, we call it SOPEC. And this sets out the rules and principles that define the standard of conduct that is expected of a member of the legal profession. So when you look at all that, in terms of the law, we are very, very well grounded, and that is the legislative basis of the tribunal. This discussion will not be complete if we don't also look at the institutional framework. In other words, who are the key players in the disciplinary process? The first player in the institutional framework is the Law Society of Kenya. As you have been told, the Secretary of the Law Society of Kenya also serves as the Secretary of the Tribunal. In this case, and she is empowered to delegate, in this case, we have Mary Kitonga, who is the de facto Secretary of the Tribunal. Then you have council members who stand in, these are council members of the Law Society of Kenya, who stand in when there is an expiry of the term of tribunal members and is not an election year. Like now, 3 members have already retired, and because 2023 is not an election year, we've had to co-opt some council members to sit with us. Then the LSK Secretariat provides the administrative support to the ADT. We do not have offices as the ADT. We don't have staff and we don't have resources. So the paperwork, the logistics, everything is done at the LSK Secretariat. And then through the Compliance and Ethics Department and the branches, the Advocates Complaints Commission and the Tribunal receive and handle complaints. So those are the key players in this. Let me also mention others that are relevant and good for your information. The judiciary. The judiciary, as I've already said, plays a very big role in the discipline of lawyers because number one, we are officers of the court. So judicial officers have power to punish advocates for misconduct in the course of pleadings or proceedings. It implements and enforces our orders. We do not have an enforcement mechanism unless we go to court. And as you know, the chief registrar is the one who maintains the role of advocates, which means that when an advocate is admitted, they are registered in that role by the chief registrar. On the other hand, if we as the tribunal strike off an advocate from the role of advocates, it is the chief registrar that does the actual gazettement of the striking out of that particular advocate. And then the High Court will hear appeals from our decisions, and that can also proceed to the Court of Appeal. Then the other player, and I'm not going to talk much about it, is the Advocates Complaints Commission, which is represented very ably here by Mr. Nyakundi, and you're going to hear about him. They play a very important role. And let me just say that for our purposes and for purposes of my discussion, the ACC is the prosecutor. If you know nothing else about the ACC, just know that the ACC is the prosecutor of disciplinary complaints. In other words, they don't determine cases unless parties agree to settle. Once they have received complaints, they look at them and they escalate them to the tribunal for determination. But they do have an in-house mechanism to encourage parties to settle issues before they come to us. So I've already talked about ourselves and how we are established under the statute. Then the Director of Public Prosecution is part of the institutional framework for the discipline of advocates. And the reason for that is that under the Advocates Act, if you look at section 61, you'll find there are offenses or conduct, or let's say misconduct, which also amounts to criminal offenses. And those criminal offenses against advocates can be prosecuted by the DPP. Now, the important thing to note here is that the DPP and the tribunal have concurrent jurisdiction. In other words, the fact that you're being prosecuted for a criminal offense, let's say betrayal of trust or acting as an unqualified person, that does not stop the tribunal from instituting or conducting or proceeding with professional indiscipline issues against you. So all these things that are listed there, although they are criminal offenses, but they also amount to professional misconduct. Then the Office of the Attorney General is a key player in this tribunal because, number one, the Attorney General is supposed to be the chair of the tribunal, but he's allowed to deputize or to appoint someone else to represent him, and that person is the chair of the tribunal. The office is responsible for the payment of tribunal members' allowances, and the AG nominates, I've already said that the AG nominates the chair, and the ACC itself, the Advocates Complaints Commission, is a department within the Office of the Attorney General. So that is an important player in the process. So Teresia, in terms of the framework, the legal and institutional framework, and the basis, the legal basis and foundation of the tribunal, I think that is enough for now.
Thank you very much, Senior, for quite an elaborate introductory of what is the Advocates Disciplinary Tribunal, where it got its instruments of power, and who actually forms that tribunal. So over to you, Senior Nyakundi. Can you also give us an elaborate?
Thank you, Teresia. I think my senior Maema has actually described the commission already, what it does. But what I would say is that even the legal framework that establishes the commission basically has been mentioned. The Advocates Complaints Commission is a body established under Section 3 of the Advocates Act. It's managed to inquire into complaints against advocates, firm of advocates, or a member of employees thereof. It does investigate and majorly prosecutes complaints of professional misconduct before the Advocates Tribunal or Committee. In addition, the Commission, as the senior has indicated, we do try to promote reconciliation between advocate and his client. So that's the major thing. The Commission itself was established in 1989 and began the operations in 1990. It has already received over 30,000 complaints since its establishment. And as Senior indicated, administratively, the Commission operates as a technical department within the Office of the Attorney General. Currently, it's based at Corporate Bank House, 20th floor. The Office of the Attorney General, this department of the Commission as it is just a commission as a technical department that prosecutes, and it has no other offices other than here in Nairobi. We don't have regional offices, although I worked out in Kisumu. All the staff and the operations of the commission are wholly financed by government. So under Section 3(1), which establishes the commission, the SEC is supposed to receive complaints of professional misconduct against advocates. It conducts investigations. It refers, prosecutes complaints of misconduct for the disciplinary committee. As I've said earlier, it promotes reconciliation. We also educate members of the public to know their rights in the advocate-client relationship. And as Senior indicated, this is actually based on Article 46 of the Constitution, that the consumer services that offered must be of high quality and that we must protect the interests of the receiver of those services. In discharging its mandate, the Commission carries out various functions, which includes developing guidelines and standards and procedures for handling complaints. We do advise the Attorney General on issues related to discipline and practice of the legal profession when requested. We, as I indicated, review and investigate complaints. The Commission, it's in its constitution, it has, under Section 1, it has commissioners who are appointed by the President. Currently, we have 5 commissioners. It's a requirement under Section 3(1) that at least one of the commissioners be qualified to be a judge of the High Court. Currently, we have 5. The chair is an advocate, and 3 others, and 4 others, and 3 others, yes. And one of the commissioners is a non-lawyer. He has joined the commission. So that's what we've been able to do. But within the commission, we have designed such a way that we have various divisions which handle complaints. We have what we call the Review and Investigation Division. This is a division that receives complaints. Then we have what we call in-house dispute resolution division. This is the division that handles matters to do with the ADR. Then we have the prosecution division, the ones who prepare charges and file them before the DT and prosecute them there. Then we have a section called, a division called Research and Outreach. They're the ones who look at issues to do with the areas or unique areas of law that affect the commission. This is its mandate. Also, they do what we call outreach programs in terms of carrying out educational activities, information. We do go out the field there to advise members of the public, inform them of the public about the mandate of the commission, how to relate with advocates, how to choose an advocate, what is expected of you when we are dealing with an advocate. That's the division that deals with that area. So the commission ordinarily, we do receive complaints. And the complaints, when receiver to file a complaint before the commission, we have designed a form, what we call a help form, to assist members of the public to file the complaint, so that if you are not so sure, they can find a way, a guided way of filing the complaint in such a way that you're also able to understand what the complaint is. And when we receive the complaint, the commission goes through the process of determining whether the complaint has substance. And if it has substance, then we conduct investigations. We conduct the investigations, and at that time is when we call other parties, like if it's an insurance company, or it's a bank, or the advocates who are maybe who were involved in the case, maybe the advocates for the defendant, and to tell us what happened in that matter. So that's basically what we do as a commission. In the issue of in-house dispute resolution, we receive complaints and determine whether they are the type that can be resolved. And since we are required to promote amicable settlement of disputes, we try to call the parties to our in-house sessions, so that they can present their issues, and hopefully that we don't proceed the matter, taking the matter to the tribunal.
Sorry to cut you short, Senior. We will get to how you proceed. We were just first asking and wanting to know the establishment.
Yes.
And the membership. You have highlighted to the members that you receive complaints against advocates.
Yes.
Who exactly brings in the complaints? Is it only the members of the public, or is it only limited to members of the Law Society of Kenya?
No, as I said earlier, anybody can bring a complaint against an advocate. We receive complaints from anybody. Members of the public and even an advocate can complain, can file a complaint against another advocate. So we receive complaints from any person. This is provided under Section 3(1) or 53 of the Advocates Act.
Thank you, Senior. You've also highlighted when members of the public come to complain to you, the commission, about a certain advocate, you give them a form. So how do they approach your complaints? How do they usually approach you so that they file their complaints?
The forms can be obtained from our offices. We also have our website, ACC, www.acc.go.ke, where you can download the form. The form is both in Kiswahili and English. They download the form, fill it, which are the particular of the advocate complaint against, the reasons for complaint, what you require, what you want to be done to have the matter resolved, and then they attach any evidence to support that complaint. Then they deliver them to the offices or scan them and then email them to the ACC through our email, acc@ag.go.ke. And so once you receive them, then or they can just come to offices here and deliver the form, or also post them to our postal box, which is 48048-00100 Nairobi. Their forms are also obtainable at the regional office of the Attorney General, because we receive complaints from all over the country. They can obtain the office from the regional office of the Office of the Attorney General. They can also get the forms from the office of the county commissioners, and they fill them. But we always encourage them to go online and download the form so that it's easier, and they can obtain the form from wherever they are without having to travel far.
Thank you very much, Senior, for that. Over to you, Ms. Mwati. Please tell us, as members, the role that LSK plays in ensuring that ethical standards are maintained in the legal profession.
Wendy can put up my presentation. Okay, thank you so much. So the LSK's role in the disciplinary process is intertwined with both the ACC and the tribunal. For Law Society, there's the Compliance and Ethics Directorate, which does several other things under the LSK mandate. But more importantly, or more significantly, it acts as the secretariat for the tribunal. In this sense, then, you can either file a complaint against an advocate, as explained by Mr. Nyakundi, through the Advocates Complaints Commission, or you can file a complaint against an advocate here at the Law Society. So you have those two options: as a member of the public, as an advocate, as anyone can make a complaint against an advocate. And those are the two places that you can do that. So when you decide to file a complaint against an advocate here with the Law Society, then we receive the complaint as the Compliance and Ethics Directorate. At that point, the complaint is not yet before the disciplinary tribunal. So the complaint is still, you can still resolve it as an advocate. We can still settle it amicably. So there's that at that point it's a semi-official process at that juncture. So that complaint, we receive it, we write to the advocate a letter that we call 21 days letter, and we give the advocate 21 days to respond. When the advocate responds or does not, the advocate may or may not respond. If he responds and we decide that there is no case to answer, then the complaint is resolved at that point. If the advocate does not respond, then we advise the complainant that you can either we refer them to the Advocates Complaints Commission to assist them to prepare affidavits to lodge a tribunal matter. Or if there are already someone like an advocate complaining against another advocate, it means they already have that knowledge of how to prepare affidavits. So these affidavits are under Section 60 of the Advocates Act. They are filed with us, the Secretariat, to be forwarded now to the tribunal members for a prima facie case to be determined at that point. So this is where LSK acts as the registry for matters that are coming before the tribunal. So at this point, you can see how to lodge a complaint to the LSK, just what I've explained, the letter, what happens when the letter is responded to and the complaint is resolved, or what happens under Section 60 of the Advocates Act. Wendy, just move to the next page. So the tribunal members are voted for during our elections, same elections as council elections. And we normally have the chairman, Maema, at this point, is appointed by the AG. The rest of the members are actually elected by members. There is usually a gap in terms of the election because a member is supposed to serve a term of 3 years. So at some point, the term of some of the members end. A full panel would ideally be a panel of 7 tribunal members. But in most cases, we'll have 3 or 4. Currently, we have 4 because some of the terms end, and before our next election cycle, there's a gap in the law where we are unable to get new members until that time for elections now for us is March next year. So because of this gap, we always have a challenge with the shortage of members, and it causes a lot of backlog. So we are talking about a tribunal of 3 to 4 members at a time, sitting a panel of 3 every Monday for only 3 Mondays in a month. They're handling around 50 files per sitting. So in the end, some of the challenges that we experience as the Law Society is that the number of members is not commensurate to the amount of cases that we are receiving. So there's a lot of challenge with backlog in terms of cases. Then we have other challenges where advocates do not update their current addresses. Then we have which causes delays in service. Part of part of what we do as Law Society is to serve all parties with the notices for the sittings. So
sorry, Ms. Mwati, you allow me to cut you short? We will get there to the challenge, yeah?
Okay.
Yeah, thank you very much. I will go back to our senior Maema. As we have heard from LSK and also from the Commission on how we approach, do we have members whom do not come to the tribunal through the representation of the Commission?
Yes, yes, we do. As my colleague, Mr. Nyakunda has explained, there are various options. You can approach as a complainant, you can approach the tribunal either through the ACC or you can file a private prosecution. So it is possible for you to file a private prosecution, and if you decide to do so, you do that through the LSK, which is the process that Mary has been explaining. So when you go to the LSK, they can either take your complaint, assuming you can prepare the paperwork, or they assist you to prepare the paperwork, but really they don't have the resources or the energy or the willingness to do that. So mainly it is where advocates are complaining and they can prepare the paperwork themselves. They don't need to go to the ACC, but the majority of complaints actually come through the ACC.
Thank you very much. And at times, there usually confusion between professional misconduct and professional conduct and professional negligence. I would like at this juncture, you bring out some light to our membership on the same.
Sorry, yeah, that's a good one. So let me explain this. So when it comes to professional misconduct, there are two strands to it. The first one is the professional misconduct that is in the act. So I think I'm going to have to use my slide so that I can have control, which is fine. You can follow me. So so let's first start from the beginning, which is disciplinary offenses against professional advocates. And in this, we need to distinguish at least three things. There is one which is called professional misconduct. There is what is called unprofessional conduct, and there is professional negligence. They are all different, and I'm going to explain those in a minute. So, professional misconduct, by definition, is breach of professional conduct. And this breach can be categorized into two. You have what is called professional misconduct, which I call sins of commission. In other words, you do something which is contrary to the rules. So that is professional misconduct. You can also do something that is called unsatisfactory professional conduct, which I call sins of omission. It is where your performance is less than what is expected. So there are those two ways of looking at professional misconduct. Now, the Advocates Act itself has listed down some offenses which are also professional misconduct. But in addition to that, as I alluded to earlier, the SOPEC, the Law Society of Kenya, has come up with, let's just call it a code of conduct, which is called SOPEC. And it also stipulates other types of conduct which would fall under the definition or description of professional misconduct. So think about the statute, and there are very many offenses that are set out there. For example, an unqualified person pretending to be an advocate, an unqualified person preparing or drawing documents that should be prepared by lawyers, or drawing documents or preparing documents and endorsing the name of the drawer when you're actually not an advocate, undercutting, sharing of profits, touting, acting as an agent of an unqualified person, employing a person who has been struck off the roll, and this happens a lot, and non-disclosure or by people who are disqualified to act as advocates. Those are in the statutes and they are very clear. Now, when it comes to SOPEC, I won't take you through all this because there are 12 types of conduct that are described in there which constitute professional misconduct, including the most common, practicing without a certificate, advertising and marketing. We don't get too many cases around that. Competence and diligence in client care or lack of it, undercutting, unauthorized use of clients' money. This by far is the most frequently committed offense by advocates. Conflict of interest cases are there, and they come, and there are quite a lot. Breach of confidentiality. This is not a very big problem. At least in my experience, I've not seen much of it. Fidelity to the law and due process, not much. Professional undertakings, a few matters come to us. Social media, how advocates conduct themselves in social media, this has become very big. We have very many pending cases against advocates on how they use social media and the kind of things that they do out there. Outside interests. In other words, if you're an advocate and you're practicing other professions, what is the kind of conduct that we expect of you? And then honesty and integrity, and this also ties down to how you handle money, how you handle your colleagues, and things of that kind. So in a nutshell, that is what you would call professional misconduct. I just wanted to mention before I finish this issue about who can file. So yes, as Mr. Nyakuni said, and as the law also prescribes, it is not true that somebody who is not your client cannot complain against you. We are in the public domain. We are a profession that is serving the public. So anybody, whether we have a professional relationship with them or not, can actually file a complaint against us. So I just thought I should make that point, and then also clarify the point that Mary made, that when matters go to the Law Society of Kenya, whether they are complaints, whether they are coming individually from complaints or from the ACC, we subject them to a process of prima facie determination. We receive there are many complaints that come, And it is not all of them that are valid. It could just be a client who is unhappy with you for whatever reason. And some of the things they complain about are totally unknown to the law, and therefore there is no case against the advocate. So once we have gone through that prima facie determination stage, that's when we decide the matters that are proceeding to hearing and the ones that are going to be dismissed at that point. Over to you.
Thank you, Senior. I would want us to have a concentration on 3 key things.
Mhm.
Members, if you're not muted, please unmute yourself so that we don't have disturbance of the noise. And in the interim, we can start posting on the chat so that we'll be able to have the questions. So, Senior, I will want us to concentrate on 3 key professional misconduct due to what is happening at the moment. We're in the era of internet where everybody is posting on social media. People are even advertising on TikTok. So how do we differentiate marketing, misuse of social media, and conducting ourselves professionally while we are offering such services via our platforms on social media such as TikToks, Instagram, Facebook, and whatnot? So that
Thank you,
until
Teresa.
time we
Yeah.
don't find ourselves having conducted or done professional misconduct.
Thank you for that. Let me get something that I'm looking for, which can help to answer your question. So, to answer your question very briefly, you need to, whatever medium that you're using. Okay, let's start from the beginning. Nowadays, advertising of professional services is allowed, but it is regulated. So what advocates are not doing, unfortunately, is to go to the advertising and marketing rules to determine what is actually allowed and not allowed. Because the fact that it is allowed does not mean that you can do it whichever way you want. There are very stringent rules about how you can market your services in a way that is acceptable to the rules. Now, the problem that you're having in social media is that people are losing sight of the boundary between when they are posting as advocates and when they are posting as anything else. So if someone is in a different setting, they will post things that would have implications on them as advocates. Our view and the way the law is drafted and the way the SOPEC is drafted, you are an advocate day and night. You are an advocate 24 hours a day. Whatever else that you do is secondary. So whatever you post, you need to ask yourself whether it is going to land you into trouble with the marketing, with the advertising and marketing rules, because you are an advocate. Anytime people see a post from you, the first thing they think of is that this is coming from an advocate. So where there is a breach, to answer your question, where there is a breach and it relates to, it doesn't even relate directly to your role as an advocate, if it brings disrepute to the legal profession, and you are deemed to have, you are seen to have acted in a way that is below the standards that are expected of a lawyer, then that would constitute professional misconduct. So it is very important to bear in mind that you are an advocate 24 hours a day, and it doesn't matter where you are. Whatever you post has a bearing on your conduct as an advocate.
Thank you very much, Senior. Over to you, Senior Nyakundi. On the same question, have you received complaints on advocates misusing their social media out there? As Senior has highlighted, there's a certain threshold that you should uphold as advocates. We sleep as advocates, we wake up as advocates, we eat lunch as advocates. Have you received some cases where our colleagues have been able to be presented before you due to such professional misconduct on social media?
Thank you, Teresa. I think Senior has explained clearly what it means, that how to behave when using social media. And I can confirm that we have received a few, and I think we have since presented some before the tribunal, so that at least they can make a ruling to also guide some of us on how to assess, because every complaint which is received here, especially those that we received from members of the public, general of the public complained that the advocate has said A, B, C, D, and it was it's wrong the way he used the information or the way he exposed himself in the media or what he commented. We have presented some of the complaints. I know there are about 2 that have been sent before the tribunal, and we are waiting to see how it pans out. then you can guide my staff on how to deal with them. Because normally when we receive a complaint of any type, we try to review and see whether it has substance, whether it has breached any of the SOPEC rules, so that we prepare a charge. I know we have prepared a few, and we'll wait to see how they will be determined. None of them so far that you have presented has been, a judgment has been entered so far, none. So we are waiting, but we have received some.
Thank you.
Teresia, I can confirm those matters are pending hearing, and the kind of content that you see there, the kind of allegations that are being made, it is the kind of exchange that happens. The content, what you say out there, is it in keeping with the dignity of an advocate? Some of them border on disclosure of confidential information on social media, use of language that is really beneath the dignity of an advocate, altercations between advocates on social media, which is being consumed by everybody outside the legal profession, and what that does to the image of the legal profession. Those are the issues that are contained in those. We are not preempting the outcome, but I can confirm to you that they are before us.
Thank you, Senior. And as we conclude on that issue of social media, is there no thin line between freedom of expression and you caveating that freedom of expression of advocates?
Would you be patient and wait to see our judgments? Once we have determined those matters, I think we are getting very close to almost expressing our views on the issues that are already before us and they've not been determined.
Thank you very much. We'll appreciate that, because I think that will be the first case that will form the precedence on how advocates should conduct themselves out there, and know the thin line between freedom of expression and misconduct on your social media as an advocate. Thank you, Senior. Over back to you, LSK. You are telling us on how advocates usually approach LSK to lodge complaints. Will you please elucidate further?
Okay. So you, as I said earlier, you can lodge a complaint either to the ACC or to the Law Society. To the Law Society, it's in the same way, same format. You can do by letter when it's not yet a tribunal matter, and it's anyone, any member of the public, an advocate against an advocate. Literally anyone can lodge a complaint against an advocate. So where someone does the formal letter, we'll go through it, we'll scrutinize, then we'll do the 21 days to the requesting the advocate to respond to that complaint. So in most cases, the advocate will respond. And at that point, we are probably likely to settle, because it's probably some issues with communication, some misunderstanding, but where the issues cannot be resolved at all, then we advise the complainant to either now go to the Advocates Complaints Commission, who can assist with drafting of the affidavits under Section 60 of the Advocates Act, or if they are an advocate and already with that skill of drafting, then they can do the affidavits themselves. Then they file the affidavits with us under Section 60. This now we forward to the disciplinary tribunal members to determine if there is a prima facie case, as Chairman Maema has just mentioned. So once the prima facie case is determined, then the affidavits are brought back to us, at which point we set the matter down for plea, and we now give it a case number. That way it now becomes a tribunal matter.
Okay, thank you very much. Senior, you can take over from when now it becomes a tribunal matter, and if you also have timelines on the timelines of how you handle your matters. Thank you.
Sure. And so just to add on to what Mary has said as a preface to what I'm going to say next, of the parties that we've been talking about that are involved in this ecosystem of complaints, receiving, etc., the only entity that does not and should not receive complaints is the tribunal. So sometimes you get emails, we get phone calls from members of the public, from even advocates, directly complaining to us at the tribunal about matters that have not been filed. We do not have the jurisdiction to initiate matters. The jurisdiction lies with the ACC, and as I've said, with the Law Society of Kenya, and you can do that as a private prosecutor. So let me then briefly take you through how the proceedings actually go. We are starting from the point where the prima facie determination has happened, and we have formed the opinion that some complaint has been established, and therefore it needs to be determined by the tribunal. So what would happen is that there will be an affidavit of complaint. In the case of ACC, they do prepare this themselves, and one of the commissioners will swear that affidavit on behalf of the complainant. If it is a private prosecution, it is the complainant himself who will do that. And there 6 copies of it are required to be filed, and then they are filed at the LSK. So it is important to note, if you are doing it as a private prosecutor, you lodge your complaint with the Law Society of Kenya. If you have gone to the ACC, ACC will prepare the affidavit and they will bring it to the Law Society of Kenya, where, as Mary has said, it will be given a case number, and you, if you are the advocate who is accused, will be summoned to appear before us for plea taking. Now, plea taking simply means, are you pleading guilty or not guilty? Or are you refusing to plead? We have had a few cases of advocates refusing to plead on various grounds, and where it becomes difficult, we just enter a plea of not guilty so that the matter can proceed from there. But let's assume a straightforward case where you come and plead not guilty, then we will give you time to respond. This is like filing your defense, which is also done by way of an affidavit. So we call that a replying affidavit. And normally we would give you 21 days, enough time for you to go and study the complaint and file your response. And once you have filed your response, the complainant, or in this case, the ACC, will be given an opportunity to look at your defense that is contained in that replying affidavit and decide whether they want to file a supplementary or further affidavit to it, where they want to clarify matters that you have raised in your defense to reinstate their complaint. Now, once that paperwork has been exchanged and filed, we go to another stage, which we call the hearing. Now, it is important to mention at this point that when you talk of hearing, at the tribunal, we do not take viva voce evidence. We go by what is called Rule 18, which allows us to make a determination based on the pleadings and affidavits that have been filed by the parties. So when we say there is a hearing, don't come prepared to argue the case before us. We only come to confirm that the parties have filed their affidavits, the periods that have been given have expired and they have not filed. In very rare occasions, we can allow you to file submissions, but normally that is not necessary because in our experience, people end up repeating what is already in the affidavit. So normally to expedite the proceedings, we'll simply give you a judgment date. So when you come for hearing and we confirm that everyone has filed what they're supposed to file, we give you a judgment date. And from there, the judgment is written and it's delivered. Once it's been delivered, what then follows, assuming that you are found guilty, is mitigation and sentencing. So that takes the same format as the court. You come and mitigate, and we get your previous record from the Law Society of Kenya, and after that, we do the sentencing, and then from there we go to enforcement, which is ensuring that you follow the orders or you comply with the orders that have been made by the tribunal. So that is how the process goes, and that's how the hearing goes from beginning to end. And there's, as I said earlier, an opportunity for appeal. You can appeal if you're not satisfied with our decision. You can also, on very rare occasions, and if you have valid grounds, you can apply for a review of the judgment or even setting aside of it. That is allowed. If, for example, it turns out that the record shows that you didn't participate in the proceedings and yet you are served, but then you come and prove that you're actually not served, or the address that was being used to effect service was not functional, so you actually were not aware of these proceedings. In situations of that kind, we would allow you to file an application for setting aside of the judgment so that the matter can start all over again. I think I can stop there for now.
Thank you, Senior. I have a question on the proceeding. I just want us to elaborate. You have insisted, as per Rule 18 of the regulations, hearing does not proceed viva voce. Is there any circumstances that you actually allow viva voce proceedings of hearing?
Yes, there are.
On what
There has been situations where advocates, for some reason, convinced the tribunal that they would want to cross-examine one of the witnesses who is involved in the case. Because remember, we are dealing with paperwork. So the affidavit may contain some information which can only be canvassed and the truth brought out through viva voce cross-examination. In situations of that kind, so long as you give the justification why you want an oral hearing, we'll grant it. But it's not the way we do things. That's the point I'm making. So that will be an exception rather than the rule.
Thank you, Senior. And while granting that exception, the person who is applying to be granted that exception, how do they approach the tribunal? Is it through an application orally or through an application drafted?
Either way. Most of the time we are very flexible because remember we are not a court, we are quasi-judicial tribunal, and yes, we try to reduce the technicalities to the barest minimum in order to achieve the ends of justice. So if you make an application during that hearing date, the one we call hearing, and before we say we are going under Rule 18, you say you need a hearing, a verbal hearing, then we'll accommodate that request if it is merited. But the general position is that because of the many matters that we have, as Mary has said, and the number that we are, and the fact that this is not a full-time job for any of us, if we were to hear everybody, the backlog will be very large and it will result in huge injustice to everyone. So the reason for going under Rule 18 is to try and expedite the delivery of judgments because we are not full-time judges.
Thank you, Senior. Over to you, Mary. Once the tribunal is done, how do you help the members to enforce?
Okay, so once the judgment is given by the tribunal, the mitigation and sentencing is done as well. We have a number of ways of enforcing. We have, in which case we can do, there's the striking off. The tribunal can strike off the member, which is the most stiff punishment. Then they also request that, they also ask the member to pay fines and costs. That, of course, is after they have compensated the initial sum that they owe to the complainant. This is specifically where we have matters involving money, payment of money. And that is the bulk of cases before the tribunal, I should mention that. Then the tribunal can also suspend. Now, for striking off, that's we simply enforce by notifying the registrar of the orders, and they are removed from the role of advocates. Then for suspension, we also notify the registrar, and then we now take the necessary action to update our systems and to also notify members on the search engine, members of the public as well as other advocates. It's also a duty of the registrar to publish suspended and struck off advocates. This is under the Act. So in some cases, and as we've seen this year, the registrar has taken up this role, which used to happen in the past. And so that publishing as well is a way of enforcement and a way of notifying the public that this person should not practice until the suspension is resolved. So for fines and costs, if the advocate pays the compensation amount to either to the law society for us to transfer to the complainant or to the complainant directly, they will have a penalty to paying fines and the costs. So in a case where they are unable to make this payment, what we do, a way of enforcing orders at this point would be for the law society to take any money that the advocate deposits with LSK for any other issues they may have. Let's say you make payment for your PC, yet you have a disciplinary issue, you have a suspension, you have money that you owe to certain clients. So we will have orders from the tribunal to take up any amounts that are paid to LSK to be used to settle those amounts. Long ago, the society used to enforce through auctioneers, something that ICC and us have grappled on and argued about for a long time. But we no longer do that. If the complainant wants to go to further enforce in terms of getting orders and warrants and all that, we just give them what we have in terms of the orders on paper and the notification to the registrar, and they can use that to go to either a civil court to now try to get enforcement in terms of now getting compensation. So those are the methods that we have.
Okay, thank you very much, Mary. Senior, you had mentioned if one is aggrieved, they can review, they can appeal, or they can make an application to set aside your judgment. But there's something that we have jumped. What are the remedies that are available to the complainant who comes before the tribunal?
Thank you. So Mary has touched a little bit on those. I'm hoping that someone is going to post the slide. So as the slide is being posted, there are a number of things that we can do once we found an advocate to have contravened the standards. Number one, depending on the gravity, we can admonish them, which simply means warning them and telling them, go and behave yourself. This is not the kind of conduct expected of an advocate. And so that when you are brought to us again, we remember that you are before us and you didn't heed the warning. So that is what we call admonishment. It's been mentioned we can suspend for up to 5 years. And once you're suspended, you're as good as struck off actually during that period, because you can't practice, you can't get a practicing certificate, and it's illegal for you to act as an advocate, including drawing up documents that are the preserve of advocates. We can strike you off the roll. This, of course, is very serious, and you'll be surprised at the very many cases that we receive, which actually merit this kind of sanction. Then we can fine up to 1 million shillings, and we can order compensation or reimbursement up to a limit of 5 million shillings. So those are the kind of remedies that the complainant should expect to get from us if we find the complaint has been proved.
Thank you, Sino. I have a further question, or I want to seek further clarity. In the circumstance of compensation, and you find maybe the aggrieved complainant, the advocate maybe ran away with 15 million, 20 million. Will you still compensate amount not exceeding 5 million?
No. Normally we order the full amount to be refunded. So compensation, remember, am I on mute? Sorry. Compensation, if we are not talking of a refund here, is where we feel that the complainant has been harmed by the action. It's like damages. It's like awarding damages. It is not a refund of the money. So when it comes to refunding of the money, whatever has been taken must be returned. But here we are talking of where we find it necessary to order something akin to damages to compensate the complainant for the damage or the injury that they have received from this misconduct.
Thank you very much, Senior. Over back to Mary. You had highlighted earlier on that there was challenges that are being faced by the tribunal. Will you please take us through that? And Wendy, please project.
Okay, I had started to talk about the shortage of tribunal members. And I'd explained that we currently right now have 4 sitting members, and in a full panel, we should have 7. So to get the full panel, we are waiting for the next election, which is in March. So in this duration, you can imagine we only have 4 members handling the number of cases that we have, which is maybe we are doing 50 files per cause list on every Monday of every week for 3 weeks in a month. So, and these are ongoing files from plea taking to hearing to judgment to sentencing. So in the end, there's a lot of backlog. There are a lot of complaints, even from members, on judgments not being delivered on time. This is because we don't have the capacity. We can't expect 4 members to be able to write hundreds of judgments within a short time span. So a lot of the timelines that we usually would have wanted to actualize, we are unable to due to this shortage. And then we have the issues of service where members have not updated their current addresses. So when we serve notifications for attending tribunal matters, we always get members now coming before the tribunal to ask for an adjournment or postponement of the matter based on the fact that they did not receive service. After COVID, from the time of COVID, we not only do the physical service, we also do online email service, which has really helped. So the service delays are very few these days, and in most cases, it's where members are actually just trying to delay the matter and not really that they have not been served. Then we don't have precise timelines where the tribunal is supposed to have completed a case. We don't. So probably would require something like a charter or service charter that would say matters that start within a year should be concluded within the year, something like that. Otherwise, we have, because of now the shortfall of members, we have matters that are still pending judgment even from 2-3 years ago. We have technological challenges because in terms of filing, we are yet to advance into automation. Otherwise, so we have to receive hard copies. When it comes to affidavits of complaint, you have to, under the Act, you have to bring 6 sets. So you can imagine every tribunal matter, someone files 6 sets of affidavits with the Law Society in hard copy. So we have a lot of challenges with space, filing, even the files themselves, and the manpower to actually do the filing, as well as space, of course. Then another issue that we have a problem with is there are no sentencing guidelines. We only have a draft of these guidelines, but because of not having particular guidelines of how an advocate should be sentenced at the end of a matter, then we have inconsistencies and many ambiguities in the process. So this is a really problematic area that we hope eventually we'll be able to resolve, at least within the chairman's term.
Thank you very much.
Mary, just with your permission, Teresia, just to add on to what Mary was saying about the shortage of members. Remember, we sit in sets of 3. So if we are only 4 now, it means that 3 of us are sitting practically every Monday in the month. And the work is a lot, not to mention the amount of time that one needs to write judgments, etc. So that explains the kind of backlog that we are having. And there's that technical challenge of terms of elected members expiring at a time which is not an election year. And it's very difficult to understand why something as simple as that has not been fixed all this time. It's been a problem that the tribunal has been having for the longest time, known to man.
Thank you very much, Sonia. And Mary, you had some proposal on how best we can curb those challenges?
I think I'll just mention a few proposals that we've discussed even with ACC recently and with other stakeholders. One item that would really assist would be digital case management. And this obviously has to do with automation and trying to to get a portal that will allow members to be able to file their documents online, just as it's been done by the judiciary right now. Of course, this needs funding, things that we are looking into. Accessibility, which would be using technology to improve for all parties to improve their access to the disciplinary process. If it's a way of a complainant doesn't have to travel all the way from Kisumu or from wherever just to come to bring us documents here. Because the disciplinary tribunal is not devolved, it means that this is the only place, the LSK Secretariat, is where you can bring your documents for filing. So it becomes a challenge for logistics, and it seems we are not actually trying to provide access to justice to members of the public. Instead, we are limiting justice for them. So if we can improve on accessibility, that will be one of the things that would improve the tribunal. Then technology would also bring about transparency, and would be able to track cases online, and will be able to manage the documents in the portal. I think the main thing that would really improve for us the disciplinary tribunal would be surrounding technological advancements, so that we can save on costs of paper, we can be able to analyze data, we can be able to maintain the security and confidentiality of documents, as opposed to having hard copies which are stored in our file, in our offices here. Then we'd also, of course, it will have an impact on the environment, as well as it will introduce user-friendly services to both advocates and to members of the public at large.
Thank you very much, Mary. We appreciate that, Ms. Gitonga. Senior Nyakundi, you've mentioned in your introductory that you have served in this Advocates Complaint Commission for the past 6 years. Seemingly, the number of complaints seems to increase. Will you have an idea of what could be propagating that?
Maybe I can proffer a guess. The number of advocates has increased, and I think it could be also an issue of morality within the profession, the ethical issues, maybe greed, and also there could be issue of advocates failing to understand their mandate very well, and maybe there is this urge of advocates trying to getting rich quickly, because most of the complaints that we receive are majorly on what we call issue of managing the finances of their clients. So withholding funds, overcharging, disagreeing on fees. So probably is an issue of that the numbers have increased, and maybe the advocates are not being advised. And also the commission has been doing a lot of sensitization of members of the public about the mandate of the commission, and probably that has informed those ones who didn't know where to take their complaints to come to the commission. That could be the reason why the numbers have increased. Because, for instance, every time the commission goes out there to conduct a CCU program in the regions, thereafter there is an increase in the number of complaints that we receive. So that could be my guess on why there's an increase in the number of complaints. And also the fact that we are now using the online system of receiving complaints. Previously, all complaints were either sent by post or delivered in our offices. the fact that people are able to complain from wherever they are by using sending them online through our email, that could have also assisted and maybe increased the number of complaints that we are receiving. That's what I would think is the reason for the increase in the number of complaints that we are receiving at the Commission.
Thank you very much, Senior Nyakundi. Senior Maima, we have a member who has a question on the same. In your submission, you told us that you're currently handling about 30,000 cases, and the number seems too large taking into account the active members in practice, which is just but a fraction. Where could the problem be, and why is the number that high?
I think that needs to be corrected, Teresia. We're not handling 30,000 cases. I think what Mr. Nyakundi said was that since the inception of ACC, they have handled 30,000 cases. Maybe Mr. Nyakundi can correct that position before we proceed.
Yes. I think what during my introduction, I said that the commission was established in 1980 and began work in 1990. And since then, we have received complaints. Over 30,000 complaints have received. On average, we receive about 1,000 complaints every year. But of course, the complaints received, some of them are just frivolous complaints. Maybe what members of the law side may not know is that we receive so many complaints which we reject before we deal with them. What we do in the commission, we have a system whereby every complaint received, we do what we call a preliminary inquiry to determine whether really this is a proper complaint to be handled by the commission, and whether this actually is absolutely a question of a person who is just filing a complaint because of misunderstanding and it doesn't know. So in the process, we receive so many complaints and then we sieve. So by the time we come before the tribunal, these are some. In fact, the complaints that we take to the tribunal are also further sieved because we are also realizing that what from the challenges the tribunal is facing in terms of manpower, the processes. So we try to, as much as possible, to leverage on our ADR to try and resolve as most of the matters before they go to the tribunal. We try to sit down with the advocate and the complainant and resolve the matter. So as I said earlier, the complaints received are over 30,000. Then we go down, we do ADRs. Then the few that we don't resolve between the advocate and the complainant, then we take them before the tribunal for purpose of now sanctioning by the tribunal.
Yeah, thank you, Bwana Nyakundi, for that clarification. So, Teresia, my take is twofold about the reason for the increase in the number. As Mr. Nyakundi said, it's obvious if the number of advocates in the role is increasing, you would expect that more bad apples will be included. We are now almost 24,000 advocates. So, and talking about that number, you can imagine if all the complaints arising against 24,000 advocates are being determined by 4 people, you can now start to understand where the backlog would be coming from, and considering that that's like the whole of Kenya. So the number itself is an issue, but more fundamentally, according to me, the reason for the increase in cases of misconduct has something to do with how lawyers are being trained, how they are being mentored, and how soon they are being allowed to enter private practice. So I think that the senior advocates have probably become too busy or lost interest in mentoring and training young people who are joining the profession to at least equip them with the knowledge that they need in terms of ethics, to see that success can come out of clean legal practice. You don't have to engage in sharp practices and professional conduct in order for you to make money, that you actually make more money if you practice your law ethically. So either we do not have enough people that are teaching that, or we do not have enough learners who are following what is being taught. And then the issue of how soon one is being allowed to get into private practice on their own. I mean, it's a huge responsibility to be a private practitioner in the legal profession. On day 2 of your opening the office, you could be confronted with a very big deal where a lot of money is involved. And here you are, totally impecunious. So the temptation is just too strong. And we have seen many cases. In fact, there are very many cases before us where the advocates simply have no defense. They just misappropriated the money. And you can see when you look at when they were admitted and when they were doing this transaction and when they came into contact with this money, this amount of money, these people were actually not prepared for handling that kind of money and for taking responsibility for that kind of money. So if the rules can be looked at both to enforce mentoring and mentorship, and even if someone is going to be allowed to go into private practice, I don't know whether they can still be attached to a more senior advocate who has proved himself in terms of ethics, so that they can feel that they are accountable to somebody, even if they are on their own, and to know that that person is looking at what they are doing to ensure that they practice law in the way that it's supposed to be practiced. So I think it is both the hardware and the software that needs to be fixed. There are no quick fixes to this, but I think, to me, those are the main reasons.
Thank you very much. Members, in the interim, you can be please posting your questions on the chat section. There's this question on the social media from David Mwangi Shege. He asked to have, please explain a bit the issue of advocates' conduct on social media, maybe just to know the lines between maybe just to know the limits and the lines. I believe, Senior, you answered that very well. And when you answered this,
yeah, I did. I did. And I think the only thing to underscore here is to say, forget about social media. Assume that whatever communication that is coming out of your mouth or out of your pen or your keyboard must be compliant with the requirements of the behavior expected of an advocate. So that it doesn't matter whether it is social media or it is verbal or it is print media, whichever media. The only thing is that social media makes it very easy for someone to reach a very large audience within a very short time at no cost. And that is where responsibility comes in. That's where people need to be responsible and know that what you've posted, you can't call it back. And even if you call it back, it will already have, chances are that it will already have been read and seen by many other people. So if you're on holiday and you are on the beach and you decide to walk naked and you post your photos because you are saying you're on holiday, that you are still an advocate. That is an advocate walking naked on the beach. It wouldn't be a tourist or somebody else on the beach. It will be an advocate of the High Court of Kenya. That is what we need to remember. Anytime you are posting anything on social media, you won't divorce yourself from the fact that you're an advocate, whatever it is that you're doing, wherever you are.
Thank you, Sim. The same, David Mwangi also appreciates the sentiments and proposes that the same be alive to the times and trends that we are living in on social media. Then we have Mary Goretti, who says that she's learning a lot about these two bodies, having left the mainstream judiciary 6 years ago. Thank you for the incisive expose. Welcome. Then we have Maina, who is asking, are there timelines within which a matter should be dealt with at the commission? Matters seems to be taking inordinately long to be determined. I believe Ms. Gitonga answered that we do not have any timelines on the same. Then we have also David Mwangi again, asking how are we angling it to be at par with the international practices on advertisement? Could we be unchanged from the barriers currently in force? Senior Maima, please.
Well, I think the advertising and marketing rules are consistent. They may need to be updated because in some jurisdictions, the rules are more robust and they allow advocates to advertise in a more robust manner than we are allowed to do here. But nothing is static. Life is dynamic. I think if a case can be made for having a relook at those rules, so long as they do not demean our reputation, that is what I think we should avoid at getting. If what you're doing is using different means to let the public know the services that you are able to offer without lying about it, because adverts, and with great respect to people that are in marketing, we all know that adverts are lies. So most of the time, what you see being advertised is not what you see in reality. But with our profession, the requirement is it's okay, you can reach out to the public and let them know what you're doing, but it needs to be factual, it cannot be over-exaggerated. So if there are any gaps in the marketing rules that are not achieving that threshold, then they should be looked at. But I've seen what happens in the West and in India and other places. I wouldn't suggest that we go to that extreme where you reduce the legal profession to the selling of chips or some cheap stuff, where the adverts are really nasty about it's not something that I would recommend, but it's not up to me. But if the question is whether we should look at what is happening in the more developed jurisdictions and see what we can borrow from them, I'm more for that idea, so long as it doesn't compromise the dignity of the profession.
Thank you very much, Senior, for that response. This one will take it to Ms. Kitonga. Still on marketing and advertisement, sometime earlier in the year, LSK had proposed to have a committee to review and amend the regulations to accord with the best practices in other contemporary bar associations in the region and internationally. Was this finalized?
Okay. Yes, the task force was formed by members, and they did submit an inception report for the council to go through. And I think we realized that it's not only the advertisement rules or the advocates' practice rules, which are the ones that are commonly being challenged every day by members, but also it involves many other laws and regulations regulating the legal sector that are quite outdated. So for the task force, they realized that the job is probably bigger than what was initially assessed. In fact, we need amendments to the Advocates Act itself. So this is, and in any case, when the task force was formed, it was made clear that this would be a longer term impact. They would have a longer term effect, because I don't think there's anything they can do in the short term, considering that amendments to the laws have to go through a whole process up to Parliament. So we have the inception report, and the council is determining the way forward for now. But in the short term, there are still no solutions to the changes that have been being pushed for in the practice rules, in the advertisement rules, in the regulations, in the Advocates Act. So I think it will just require patience from all of us.
Thank you very much, Ms. Kitonga. From Lucy Gakeri, kindly advise on the length of time taken to get a ruling/judgment before the Advocates Disciplinary Tribunal. She has a matter pending ruling since 2020.
I think we addressed that issue. We can't give any timelines. There are many factors against or militating against the early delivery of judgment. Sorry.
You are breaking at some point.
Oh, sorry. Just a minute. Give me a second. Can you hear me, Teresia?
Yes, we can. Thank you.
Yeah. So I was saying it's unfortunate. The backlog is huge, and we can't give any timelines. So we are doing the very best that we can. But if you feel that your matter has taken very long, say it's been adjourned so many times, and every time it comes up, judgment is not ready, and you're given a far-off date, please feel free to write to the Secretariat. We can find out what the problem could be. We have had cases where some files were in the custody of past members and who did not write judgments by the time their term expired. So when you write a letter like that, we can try to find out where the file is and what the reason for the delay is. Most of the time, we'll unclog the system and get the ruling out. But we are not giving any assurance to anybody on any timeline that we can deliver rulings and judgments. We are very, very strict constrained. We are very, very strained by the backlog, and we are few.
Thank you very much, Senior. And even to add on that, Ms. Kitonga had alluded how the Act is silent on the same. So maybe we can also consider amending the Act to help expedite that. There's another comment. So
no, amending the Act will not help, Teresia.
Yes,
amending
Senior.
the act will not help, because imposing timelines on trained staff, I mean, it won't work. The only solution to this is amending the rules for the appointment of more members. These rules have been the same forever. When the profession had a maximum of 2,000 advocates, the members were 6 or 7.
That's a good food of thought, Senior. Thank you. We have another question from Faith Cherono on professional misconduct, specifically unsatisfactory conduct, that is sin of omission. Can one lodge a complaint against an advocate when they refuse to release, for example, completion documents or agreements under unsatisfactory conduct?
Yes, they can.
We have another
Yes.
one. Thank you. This goes to both the seniors. Do we have adequate public awareness mechanism, especially for the commission and the tribunal? We'll start with you, Senior Maima.
That is what we're trying to do in this webinar, creating awareness. I'm sure we can do more and should do more, but resources are limited. We would want to do more, but we are unable to do because of the resources. We even had a service week. Was it July, Mary, when we sat for 5 days consecutively? And I'm not sure that it was even publicized or anyone got to know of that extra effort that was made. We're going to have another service week sometime in November, again, to try and work on the backlog. So there's a lot that we are doing, but I do agree it is not being publicized. And what seems to be known out there is that this self-regulating mechanism of the Law Society does not work. They are colleagues with colleagues, colleagues dealing with colleagues, and it's a cartel. It doesn't work. And that's actually not the truth. We need someone to speak for us and say that we are doing a good job.
Thank you, Senior. And yes, you're doing a good job. And as LSK Nairobi branch, we'll take up the initiative every time you have, just like how we usually present to our members every time our court session has service week. We will also ensure that we post the same for our members through our newsletters and on the respective WhatsApp forums. Thank you. Over to you, Senior Nyakundi. Do we have adequate public awareness mechanism for the commission? Senior Nyakundi, can you hear me?
I think I was still muted. I wanted to say that for sure we also don't have sufficient mechanisms for advocacy. This can be seen even for recently we had commissioners who were asking, I didn't know about the commission when they were appointed. It's a sign of that they don't know about the commission, even its existence and its mandate. As a commission, we are still trying. Of course, there's the issue of funding, inadequate funding, but we are always trying to promote the commission by going out to the field to talk to the public. We realize with the county commissioners, we go there, they call barazas, and then we talk to them with the public about our role. And in the process, also mention the advocacy committee, because we actually intertwined. They know the LSK. So when we mention the mandate of the Advocacy Commission, we also tell them that there's another body that we work with. We also been trying to do what we call the webinars. We have recently done one on the issue of a thin line between professional negligence and professional misconduct. We also go to the schools. We are going to the Kenya School of Law. We just the other day had last month we had presentations. We spoke to the classes there. We also do speak to the law schools, the universities. We go to especially the final year students. We talk to them, tell them about the Advocacy Commission, about the disciplinary process, so they get to know the bodies. But of course, maybe it's not enough. We are also trying to do the same using our website, and then we intend to revamp it and then put much information about what we do on the website, so members of the public can know about the commission.
Thank you very much for that as well. I'll also urge you as a member of the bar, it is indeed true not majority of the people actually are aware of your work, albeit some of us have practiced before the ATP, so we do know about it. And I will urge you, both the commission and the tribunal, to maybe try and create space and time when LSK, both the branch and the National Council have events, you can have a booth so that you can be able to raise more awareness to our members. To Senior Maema, there's someone who's requesting, maybe you can say something about advocates' ethics in virtual appearance, like dressing and addressing court from bedrooms. Thank you.
Yes, thank you very much, Teresia. That goes back to exactly what I was saying earlier. Let's forget about the medium of communication or how we are being viewed and go back to the basics. If you are practicing as an advocate, what will be the level of decorum expected? So the fact that it is virtual changes nothing. As I was saying, the fact that you're using social media changes nothing. So the way you would appear before a court physically should be the same way you would appear if you're doing it virtually. So those who are lowering the standard by taking or conducting pleadings from locations that are less than dignified, I think ought to pay attention to these voices and just know that they're not doing the profession any favors and they're not helping the profession at all. I am at home right now, if you can see me, but because of this webinar, I dressed up so that I can appear as an advocate. Because we are advocates, when you're performing these kind of duties, there is a way that we are supposed to appear. So I would just urge members that you may be comfortable with that. It may be the best thing for you to take the call from your bedroom, from your bathroom, but think about the profession, think about the public, think about everyone else, and more importantly, the dignity of the profession. What kind of profession are we bequeathing to our children? Are they going to say that they don't want to become advocates anymore because of you, because of what they saw in you? We have a responsibility to protect the dignity of the profession.
Thank you very much, Senior. And to Ms. Kitonga, I understand that the LSK has a code of conduct on the dress code. Could you all tell us more on that as well, and how much you've created awareness to the members on the same? Sorry,
Okay, the code of conduct, I think it was published in 2015, if I'm not wrong, and it does cover the issues on how to dress, the dress code. Then there were guidelines that were published, perhaps I think in 2013, under Chairman Eric Mutua, and they were also defining how advocates should dress during, of course, while on duty in courts or otherwise. We have republished this same dress code guidelines earlier this year for the membership to take note. So it's not new. It's not new guidelines. They have already been in existence. The code also covers this. The code is, I think, most advocates are very well aware of the code. When it was published around in 2015, it was a lot of awareness was created around it, highly circulated. It's something that is readily available online. So we still get a lot of complaints against advocates on the dress code, but most of these issues have arisen more recently when the online platform came to power during COVID. So I don't know if the solution would be to have guidelines on dress code for advocates while on online platforms, or because for already there exists the dress code. So unless we to specifically make it about online platforms. So other than that, I think advocates, just as Chairman Maema has said, like, we should know how to conduct ourselves, despite having rules about it. We should know the conduct of the conduct that becomes an advocate. Otherwise, it's professional misconduct.
Thank you very much, Ms. Kitonga. Further to that, recently the Chief Justice also released a writing on how advocates are expected to conduct ourselves during virtual courts. So let us adhere to the code of dress code is presented by LSK, and also the notice that was done by the Chief Justice. Finally, we have Mweni Kalola, who is she's saying this is very insightful and educative series. Thank you to Senior Maima, Senior Nyakundi, our Commission Secretary, and Mary. You have made excellent presentation and clarification. So yeah, I'll give you your flowers. David Mwangi again is asking, maybe the lawyers live in bedsitter, but on a light note, and is also thanking the presentation today. We also have Nagea Daido, who's much appreciation to the panelists and moderator for the enlightening and insightful discussion. Thank you very much. Well, members, with no further ado, since I don't see any other person who has written any chat or has expressed anything on the chat box or even rose their hand up, this is the time that we'll want to thank our panelists for such robust presentation, giving us so much clarity. And yes, Ken, the notes will be shared together with the presentation. We will share to all our advocates. And if you don't usually receive the newsletters from LSK Nairobi branch, please make sure you write your email on the chat sector so that we'll be able to send to you whatever has been presented today. Before I close, I want to acknowledge the presence of our LSK CEO, Madam Florence Muturi.
Hi everyone.
We want to see
Tess,
our CEO.
can you? Oh, you want to see my face? Let me see whether that is possible. Can you see my face now?
Yes, Madam CEO.
Okay, good. I have been following the session. That was a very good one. Thank you, Senior Maima. I'm happy to see you. CEO Nyakundi and my colleague Mary. And thank you, Tess, for the good moderation. Members, have a nice afternoon. Thank you.
Thank you, Florence.
Thank you very much, Madam Florence. That is our CEO. Members, in case you might not know the face of our CEO, there she is there. Yeah, please share your emails on the chat forum. And we've, as LSK Nairobi branch, you've also shared our email so that you can also write to us and do, in case we don't see it. But this is a recorded session, so we'll be able to get to see your emails. And lastly, this is to Senior Nyakundi. You had mentioned where your offices are, but it was not clear to the members. Could you please remind the members? And also the website address that you had mentioned earlier on.
Thank you, Teresia. Our offices are on Corporate Bank Building, which people call the Bomb Blast or the Bell Bottom, on 20th floor. Corporate Bank Building, 20th floor. That's on the junction of Moi Avenue and Haile Selassie on 20th floor. Our website is www.acc.go.ke. And if you want to communicate with us, just write to acc at our email at ag.go.ke. And they will receive the information, what they want to do. If you want a complaint form, for instance, you write that email, we will send the complaint form to them, or what we call the help form, to assist you to file or lodge a complaint. I hope I'm clear this time.
You're very, very clear, Senior. And as a Nairobi branch, you'll be able to send that information here. Thank you very much, Maria Goretti. One day, maybe we will go and join the Media Fourth Estate. Thank you. Well, members, with no further ado, I want to thank our panelists, Senior Maima. That was very insightful. Senior Nyakundi, God bless your soul. And Ms. Kitonga, thank you very much for taking care of us at LSK. As much as we always disturb you with matters of compliance, you still found time, the three of you, to come and have this discussion, to come and give us more insight and clarity on what happens between the Advocates Tribunal, Disciplinary Tribunal, and the difference between the Advocates Commission. Now we know the difference, and we know also the nexus and where LSK comes in. And above all, we will be very careful to adhere, to conduct ourselves as advocates of, because this is a noble profession, and we will not want to come before Senior Maima and pleading, yet we do not even have a defense, as you have alluded. So with no much further ado, members, I want to thank you for joining us. I want to thank you for being patient, for asking questions, for showing interest in your questioning and your interaction. This is the first series of Know Your Tribunal of 2023, and I hope you will be joining us again next month as we bring to you the next series of the Know Your Tribunal. God bless you and take care. Thank you.
Thank you. Thank you, Teresia. Thank you, everyone. It's a pleasure.
Thank you so much. Have a good afternoon.
Thank you.
Bye-bye.
Thank you. Thank you, everyone.
Bye-bye.
Bye.
Bye.
Thank you, everyone. Bye-bye.
Bye.